This is Colin O'Keefe here with Tuesday's episode of LXBN TV. Are human genes patentable? That's the question the Supreme Court considered last week as it heard oral arguments in Association for Molecular Pathology v. Myriad Genetics. Joining me today to analyze those oral arguments is Antoinette Konski, partner in Foley and Lardner's Palo Alto office and also author on the Personalized Medicine Bulletin, where she's been tracking this case every step of the way. Antoinette, first, what are your reactions to the oral arguments? What stood out to you?
Well, what stood out to me first was that I did think that the justices were well briefed and informed on the issues before the court. And I thought that the questions that they asked the parties and the U.S. government, who was appearing as an amici, really set forth the difficulties that they're having in grappling with how can one still maintain and promote innovation and invention and investment while keeping from patent protection things that are really products in nature and as he did in the Prometheus case, the natural laws. Recall this case has to do with the isolation, characterization, and further patenting of genes that have been known to be correlated with a higher risk of cancer, the BRCA1 and BRCA2 gene. Myriad did invest a good deal of money in the research and development of this underlying technology, which eventually provided a very valuable diagnostic test. They patented any aspects of that technology. They patented the full gene as it appears in the human body, only that it's in an isolated form, which means that it's been separated from the human body. They also patented more, what we call more man-made type embodiments, that is cDNA, and also fragments that are used to amplify and detect these genes in a patient sample.
As you mentioned, the Supreme Court is weighing the balance between incentivizing innovation and making sure that those innovations are as widely available as possible, especially when they're as important as detecting the genes that cause cancer. So, second, any insight as to which way this might go and what impact it will have?
It appears from the oral argument that what is most likely to occur is that they're going to split the baby, that they'll likely hold that isolated genes that are isolated from the human body with the full sequence, what we call introns, within the exons, which code for proteins, that will be patent ineligible. Recombinant DNA and cDNA, which are man-made forms of genes that code for proteins, etc., they will be patent eligible. I don't know what they're going to do with respect to smaller fragments. It's likely that smaller fragments may also be held to be patent ineligible unless the patentee can find something that is really unusual and highly commercial and translational with respect to their use.
This is an interesting case to watch. I don't think it's an overstatement to say that this is a landmark case, as many people both inside and out of the industry look to see what will happen, as it could have a profound impact on the future of medical research and the future of healthcare. Again, that was Antoinette Konski of Foley and Lardner. For more of her insight, be sure to visit personalizedmedicinebulletin.com, where she really has a wealth of insight on this particular case and many other associated cases. And again, visit us at lxbn.com for more of these LXBN TV video interviews, along with curated commentary from the LexBlog Network's more than 8,000 members. Thanks for joining us today, Antoinette.
Thank you.